Question. Discuss the unique characteristics of the Indian Constitution, such as its length, federal structure with unitary bias, and the blend of rigidity and flexibility. Namaskar, friends. Today we will discuss the Indian Constitution, a unique lex loci, meaning India's most unique document. The Constitution of India is not merely a legal document but a living instrument that reflects the aspirations of more than 1 billion people. It was enacted on the 26th of November 1949 and came into force on the 26th of January 1950. This is the supreme law of the land. It is a unique product of historical experience and legal craftsmanship. Dr. B.R. Ambedkar rightly said that it is flexible enough to yield to change, yet strong enough to survive. In simple words, this is the soul of India. It is the longest written constitution in the world, made keeping in mind India's geographical, cultural and linguistic diversity. It is a perfect blend of rigidity and flexibility, neither too rigid nor completely loose. It is a bridge between the past and the future. Now let us talk about its three unique characteristics. 1. Longest written constitution. Length. Originally it had 395 articles and 8 schedules. Today it has more than 448 articles. It covers administration, fundamental rights and even small procedural details. 2. Federal structure with unitary bias. It is a quasi-federal system. Power is divided between the center and the states, but in emergency, under Article 352, 356 and 360, the center becomes all-powerful. This is to maintain India's unity and integrity. 3. Blend of rigidity and flexibility. Under Article 368, small amendments can be made by simple majority which is flexible, and big amendments require special majority plus consent of half the states which is rigid. This mixture allows the constitution to adapt with time while protecting its core. Now to understand these characteristics, let us look at some important cases in chronological order. Each case explains the issue, arguments and the court's reasoning clearly. The first case is Sri Sankari Prasad versus Union of India 1951. In this case, the main issue was whether Parliament can amend fundamental rights using Article 368. The petitioners argued that constitutional amendment also comes under the word law in Article 13 subclause 2, so rights cannot be abridged. The court rejected this argument and held that Parliament has full power to amend any part of the constitution. Constitutional amendment is not law under Article 13. After this came the second case, Sajan Singh versus State of Rajasthan 1965. Here also the validity of the 17th Amendment was challenged. The court followed the Sankari Prasad judgment and reaffirmed that Parliament's amending power is supreme. But in 1967, the Golaknath versus State of Punjab case completely changed the court's earlier view. The issue was whether Parliament can take away fundamental rights completely. The petitioners argued that fundamental rights are transcendental and no one can touch them. The court overruled the previous two cases and held that Parliament cannot amend Part 3 to take away fundamental rights. Article 368 only provides the procedure, not the power. This controversy ended in the 1973 Kesavananda Bharati versus State of Kerala case. This was the famous 13-judge bench. The issue was the challenge to the 24th Amendment giving Parliament unlimited amending power. The court created a new doctrine called the Basic Structure Doctrine. It held that Parliament can amend any part but cannot change the basic structure, such as secularism, federalism, democracy and judicial review. The court explained that you can repaint the walls of the house, but you cannot shake the foundation, otherwise the whole house will collapse. The last important case is Minerva Mills versus Union of India, 1980. Here the clause of the 42nd Amendment giving Parliament unlimited amending power was challenged. The court struck down that clause and held that judicial review is part of the basic structure and limited amending power itself is a basic feature. The main articles connected with this topic are Article 1, Union of States, Article 13. Laws inconsistent with fundamental rights are void. Article 368. Amendment power. Article 32 and 226. Writ jurisdiction. And Article 352 and 356. Emergency provisions showing unitary bias. Friends, the uniqueness of the Indian Constitution lies in its organic nature. It is a bridge between the past and the future. By blending the British parliamentary system with American judicial supremacy, the framers created a living social document. The basic structure doctrine works like a safety valve. The Constitution can grow, but its soul remains intact. It is a beacon of democracy because it maintains the perfect balance between the authority of the state and the liberty of the individual. In short, it is not a stone but a flowing river that changes its path with time but never leaves its boundaries. Jai Bharat,